Hello, and welcome to Horns of a Dilemma, the podcast of the Texas National Security Review, TNSR. I'm Doyle Hodges, Executive Editor of TNSR. On this episode of Horns, we listen in to another talk given at the University of Texas Austin at the Strauss Center. The talk is introduced by Professor Bobby Chesney, the director of the Strauss Center, and hosted by Claire Hewitt, a Brumley Graduate Fellow in the Strauss Center. The speaker is Dr. Catherine Latriante, a professor at Georgetown University with extensive experience in government related to cyber law, and of relevance for this discussion, the author of a 2015 article in the North Carolina Journal of International Law entitled Countering State-Sponsored Cyber Economic Espionage. In this talk, Latriante discusses the concept of economic espionage, that is, the use of state resources in order to obtain private intellectual property not for the benefit of the state, but for the benefit of industries and companies within the state. Latriante discusses whether and why such practice might be illegal under international law, and what recourse is available under international law for states that are a victim of these practices. Let's listen in.
Hey everybody, thanks for being with us today and welcome to the virtual campus of the University of Texas. I'm Professor Bobby Chesney. I'm the director of the Robert Strauss Center for International Security and Law here at UT. The Strauss Center has a lot of programs, including a cybersecurity program, but the program affiliated with this event is better described as our Brumley Graduate Fellows program, which is one of my favorite things we do, where we have a highly competitive selection process and get students from grad schools and grad programs across the university to become part of our operations, including, among other things, matching them with faculty from units outside their own, supporting them in their research, and supporting them when they identify an outside scholar or policy figure that they would love to meet, love to have come speak to the community. And today is one of those occasions. So let me introduce to you one of the Strauss Center's all-time favorites, Claire Hewitt. Claire's been with us for a number of years because she's getting both a law degree and a master's in global policy studies, so a joint degree candidate, and has been a mainstay in our cybersecurity courses, among other things. She's a shining example of the talent we have here at UT, and we're going to miss her next year when she goes off to practice law at Norton Rose Fulbright in their DC office. Claire's previously worked for the State Department at U.S. Embassy Tokyo. I believe she worked at DOJ at the International Affairs Office. And so I think all these topics come together in the presentation that we're going to be hearing shortly. But first, let me turn it over to Claire. Claire, the floor is yours.
Thank you so much, Professor Chesney. I will definitely be missing the Strauss Center next year as they go off, but I'm excited to stay involved for the rest of my life with UT in this group. I'm so excited to be introducing Dr. Catherine Latriante today. She's currently a senior researcher at Georgetown University, a senior associate in the Technology Policy Program at CSIS, and a senior fellow at the McCrary Institute for Cyber and Critical Infrastructure Security at Auburn University. Previously, she served as the Brent Scowcroft Scholar at the Atlantic Council. She's also the founder and former director of the Cyber Project at Georgetown University, where she's taught and written on international and national security law and international affairs and technology. At Georgetown, she founded Cyber Project in 2008 and the annual international conference on cyber engagement as well, which draws on the experience of government practitioners, industry representatives, and academic scholars, and it provides technical, corporate, legal, and policy perspectives from the international community. Latriante served as the counsel to the President's Foreign Intelligence Advisory Board at the White House on the Joint Inquiry Committee for the Senate Select Committee on Intelligence, investigating the 9/11 and terrorist attacks, and as an assistant general counsel at the CIA and in the U.S. Department of Justice. She's internationally recognized as an expert on international law and cyber conflicts. She's testified before Congress and NATO on cyber issues. And we're so excited to have her here today. So thank you so much, Dr. Latriante, for joining us.
Thank you, Claire. Thank you, everyone, for having me today. First, a little background. To explain kind of, you may have, I think what maybe prompted the request to have me come and talk to you about economic espionage is an article that I wrote in the North Carolina's Journal of International Law and Commercial Regulation. That article came out in 2015. To give some background as to why I wrote that article, kind of why I was focused on economic espionage at the time, it'll be useful to just mention two things. In May of 2014, the Department of Justice had indicted 5 members of the People's Liberation Army, PLA, of China. This indictment and the charges were for computer hacking and economic espionage. This was the first time that there were criminal charges against a known state actor for hacking. So it was pretty significant. And so at the time, I took note of that and began thinking about the issue of, well, what is changing when it comes to particularly cyber espionage, and specifically what I usually term as economic espionage, and how that might be different from the traditional political military espionage. And so I started writing a short paper that was meant to be the basis for a workshop that was going to be taking place in Paris. And it was going to be mainly governments, but also academic representation. And it was the French delegation that asked me to lay out what I thought was the U.S. government's policy perspective and the distinction that the U.S. has traditionally made between economic espionage and political military espionage. So this is how the basis of the Law Journal article began, was because I was using it for a kind of, I guess, a white paper of sorts for this workshop. Now, while I was writing this article, it took me quite a bit of time to kind of get it out. It was published in the winter of 2015. But in September, it's not mentioned in the article, but in September of 2015, another event happened, it was significant in that it was the first time that it was President Obama and President Xi came to an agreement. And in that agreement, there were a number of elements dealing with cyber activities, but one specifically relevant to our conversation today was in that agreement, they agreed that they wouldn't be sponsoring or knowingly be a part of what they termed cyber-enabled theft of intellectual property. So there has been much discussion since that agreement in September of 2015 as to whether China has complied with that agreement. But we can put that aside for now. I wanted to just mention those two events that, particularly the indictment that really started getting me thinking about writing something, and then a workshop that caused me to sit down and actually put my thoughts together on this. Now, you may or may not have had a chance to even see the journal article, and I wouldn't be surprised if you didn't even get through, even if you looked at the title. It's quite long, and honestly, it took me about a year to write. It wasn't the only thing I was doing, but still, that was a long time for me to write a law journal article. So it's pretty dense. So I wanted to kick off the conversation with kind of the big picture of what the article was about, what I was trying to do. So I gave you a little bit of background on what brought me to it. Now, what's important is definitions. Typically, lawyers kind of make a lot to do about definitions, and that becomes important. And in the article, but also in my work in the government, there has traditionally been a difference and definitionally and operationally between what is called economic espionage and what is in the article, I talk about economic intelligence. Now, economic espionage is typically described as a state using its national intelligence resources and assets in order to steal information from the private sector of another country. But the important distinction that will be important, and you'll see in a minute, is that they're using that information not necessarily to enhance their national security policymaking, but to actually provide a benefit to their own private sector companies within their country. Now, that is in the article in what I discuss as economic espionage. Now, traditional political military espionage also involves a country using its national intelligence resources and assets to steal, collect intelligence information from abroad, whether targeting individuals, governments, government officials, it could be terrorist organizations. And that information is used to enhance the government's foreign policy making. right? So traditionally it's done in a clandestine manner, and sometimes it's called, intelligence collection. But that's what, when we refer to political military espionage, that is what we're talking about. Now, within that category, there is economic information that is often collected by a state's intelligence services that is used to benefit that state's policymaking. So it could be the examples I give in the article. It could be economic information with respect to currency valuation, or it could be about trade negotiations. But the purpose and the use of that is to go back to the country in order to inform their national security apparatus or foreign policy making bureaucracy. It is not used in order to benefit the private companies to get a competitive edge against competitors globally. Now, the United States, and this is what the French had asked me, because they really weren't quite sure about the history of why the United States claims to make a distinction between what it does in the realm of political military espionage, meaning using our intelligence services to collect information that's not publicly available from abroad and using it in our policymaking process or our national security bureaucracy. And the distinction that the U.S. draws between that and the economic espionage, which is you're using your intelligence apparatus to collect private information. Typically, what I talk about in the article is intellectual property from other countries' companies, and your intent is to use that to provide it to your own companies to give them an advantage in the global economic trading community. So the U.S. has traditionally, and in the article, I try to go over the history of this because the French had said, well, we're not quite understanding what the distinction is. Other countries don't necessarily draw that distinction, and China historically has not drawn that distinction. So the U.S. historically, and this goes back to before we had the internet, so we're not talking about just the cyber-enabled economic espionage, but in the physical realm, if you will, in the 90s, we saw that there was quite a lot of discussion, some of it which became public because there were studies done, where the U.S. was concerned that even our allies were conducting economic espionage against our private companies in order to benefit their private sector. And so the U.S. intelligence community actually looked at this issue. There was a debate whether the U.S. should get in the business of doing this also in order to level the playing field, as they were discussed. Ultimately, it was decided that the U.S. was not going to be doing this, and particularly the focus was on the intelligence community because they had the capabilities to do this. The thought was that it would be the intelligence community that would be asked to do this. And so it was decided, and there was a 1990 or 1991 report or study that was put out and is publicly available now by the CIA, saying, in fact, the agency didn't think that it was going to be appropriate for an intelligence agency to actually do this work. So it's certainly been in line with U.S. government practice that there's this distinction that's made between collecting intelligence, foreign intelligence collection for national security purposes versus foreign intelligence collection targeting private entities, but to benefit your own private companies. So in the article, I spent some time talking about that distinction before I then begin to talk about international law. Now, the reason why I began to think about the international legal aspect of the issue was before the indictments in 2015 of the 5 PLA members. There was a concern, and there continues to be a concern in the United States, that the level of the, if you will, cyber-enabled IP theft is getting to a point where, and the economic figures for damage vary, but even if you take a conservative, what some of the conservative estimates, you're talking about hundreds of billions of dollars of damage done to the U.S. economy because of this cyber-enabled IP theft. And so it became a point of much concern within the US government. And as I began looking at this, a question was raised as to what could the United States do, aside from kind of diplomatic negotiations and agreements like the Obama-Xi agreement. Were there other levers under international law, other steps that the U.S. as a target or a victim of this activity could actually do in response? So that's where, and in most of the time in the article, most of the time I spend on looking at customary international law and the rule on non-intervention. And so, just briefly, I don't know, hopefully we can get into more refined questions and we can dig into the elements of the rule on non-intervention. But just briefly, in international law, they're part of customary international law. That's actually this rule, if you will, has been around prior to the UN Charter, but it continues after the UN Charter went into force. It's widely accepted as binding universal customary law. And this rule, in a nutshell, says that states are prevented from interfering or prohibited from interfering in the internal or external affairs of a state on the issues that are reserved for the state to decide on its own. So any topic or any issue that international law does not regulate and leaves up to the state to decide on its own, typically the examples are like political issues, economic issues, cultural issues. It could be social issues. These issues are, in the language of international law, considered part of the domaine reservé of the state. And the state is to be free to make these decisions without any outside intervention into those areas. Now, that's one part of the test, if you will, for the rule. The second part, and I would say the second part is probably the most controversial in that some people disagree about the nature of what coercion means. And in order for this activity to be a violation of this rule, it not only has to intervene into one of these areas of domaine reservé where the state has the free authority to decide independently from any outside interference, but it also has to be a coercive act that the alleged perpetrator or violator, the alleged state is doing. So it's got the disagreement, I would say, debate is about what coercive means. And in other words, what threshold of activity do you need in order to find that a state has actually conducted a wrongful intervention? Now, what we do know from the International Court of Justice, and particularly the Nicaragua case, is probably the clearest that we have under international law, is that we do know that for an act to be violative of this rule, it's got to be more than just interfering. It's got to be, and that's where the coercive element comes in. We also know from the Nicaragua case that uses of force are always considered also, uses of force as prohibited under the UN Charter, Article 2.4, are always considered to be interventions, but not all prohibited interventions are uses of force. So it's only the most, if you will, egregious of the interventions. So you can have non-forcible interventions that are coercive in an area where the states has a freedom to decide on its own, which amount to a violation of this rule. So what I did in the article was I took this customary rule, I looked at it, and I tried to, based upon the precedents and state practice, see if there was anything within the rule and how it's been understood by states over time that would be relevant to looking at the cyber-enabled IP theft, and whether cyber-enabled IP theft conducted by a state against another state, and stealing the private company intellectual property of private companies of the state to be used for its own state private sector benefits, if this could trigger or amount to a prohibited intervention. And so I go through the steps. Now, my own conclusion is that it could. I would say not everyone necessarily agrees, but it does come down to the aspect of coercion. If you believe that the test of coercion has been met, surely deciding kind of economic your economic policy and engaging on the international global market will be part of what's considered a domain reserve or an issue of which the state can decide freely without interference. So it all comes down to on the threshold of coercion. If you are stealing, and where I draw the line is that I basically say that if you're effectively blocking a state from being able to be competitive economically on the global market, you've effectively, it meets the criteria of a coercive act. You've prevented a state, because of the massive IP theft, from actually conducting their international economic relations or even domestic policy related to that, the economic international market, if you will. So in the whole purpose of me looking at this, though, was under international law, if a state has actually suffered a breach of an obligation, and arguably if you violated the rule on intervention, then the target state or the victim state, in this case, I was thinking the US, we're thinking about the cases that were mounting up that China was conducting against the US, what could the US lawfully do in response, aside from kind of the diplomatic options? And that's where, in that second half of the article, I looked at the law of countermeasures under the law of state responsibility. Once again, part of customary international law. And since 2001, the international lawyers have quite a bit of, if you will, data or analysis to kind of read and think about and to apply, because the International Law Commission came up with their final draft. It's no longer a draft, but the final articles on state responsibility. And within those articles, they deal with the law of countermeasures. So that was I think it was at least 20 years in the making. But they laid out both the procedural and substantive requirements for conducting countermeasures. And this is where I thought it fit into the U.S.'s concern. What measures could the U.S. take in response to arguably an unlawful intervention with the cyber-enabled IP theft? And what I talked about in the article was you would look at the law of countermeasures and what would be allowed within countermeasures. Now, countermeasures come with quite an extensive list of, as I mentioned, procedural and substantive requirements. It is not something that to be taken lightly. There are very strict rules, procedural rules in place from which that you have to follow in order for it to be a lawful countermeasure. For instance, they cannot be forcible, meaning they cannot violate Article 2.4 of the UN Charter. Typically, there's a preference, although not a requirement, that you give notice if you're going to conduct a countermeasure so that other state can actually become compliant. So if you conducted a countermeasure without any, if you will, justification, you would be doing something illegal. So that's why it falls under the if you will, secondary rules on state responsibility. It's kind of the countermeasures as well as other justifications for wrongful action kind of exempts you from any wrongful act yourself. So in conducting the countermeasure, as long as you follow the procedures of countermeasures, your action would be precluded from being wrongful, if you will. Doesn't make it legal, but it is, in some words, it's justified. So, and I can go into details about what the rules are with respect to countermeasures, but generally speaking, if you think about it, if a state suffers a breach of an obligation owed to it under international law, now that can be based on treaty, or in this case, what I'm talking about is customary obligation that you won't intervene in a state's affairs. If a state suffers that breach, then the obligation is upon the breaching state to come to a point of complying with its obligation. And the victim or target state can actually conduct countermeasures in order to get that offending state to become compliant in its obligations. So once it stops conducting, in this case, the intervention, arguably your right to countermeasures ends. Now, there's some debate as to how long that right can continue, particularly because you also have the right to have reparations paid, and if you can continue your countermeasures until those reparations are paid. But there is some debate on that. But generally speaking, that's kind of what countermeasures are about. Now, in the article, I also talk about, because I was asked to. Originally, when I was writing this for the workshop, I was only going to deal with customary law and the rule of non-intervention. But because there were quite a few trade lawyers, and I don't teach on international trade law, but because the workshop was going to entail some discussions about the WTO and the possibility of the U.S. bringing a claim in the WTO against China for some of these cyber-enabled IP theft, they asked, okay, would you kind of talk about at least your thoughts on whether the WTO would be an effective regime for recourse for the U.S. when it comes to the cyber-enabled IP theft? And so in the article, I also review the WTO, specifically the TRIPS agreement, which has a provision for the protection of intellectual property. It's basically the most comprehensive, if you will, international agreement on protection of intellectual property. But as I outline in the article, there are a number of challenges, if you will, and difficulties with using the WTO if you're trying to seek recourse, specifically for cyber-enabled IP theft, or what is generally called economic espionage. So although I don't rule it out, I do highlight in the article the number of challenges. My emphasis is on the customary law and the rule of non-intervention overall in the article. Now, that's a general take, a general view of the journal article, and also in general economic espionage. I want to ask Claire, because Claire also mentioned that you all might be interested in discussion of some of the negotiations going on with cyber norms at the UN and otherwise, and how it relates to even international law. But putting aside economic espionage for a minute, and I know that's kind of the topic, and hopefully we'll get into some questions on that. When I was speaking with Claire earlier, she thought this might be interesting also to talk with you. Probably since about 2010, I became more involved, or let's say first academically interested, and then more involved where I was part of some of the participation within the group of governmental experts in the UN. Back it up a little bit to tell you about the history. In 1998, for the first time, at the UN and generally in international kind of relations or law, the first time the Russians tabled a resolution at the UN. And what they were requesting or tabling was that we negotiate a treaty that would, in effect, prohibit cyber warfare. So this was 1998. Now, at the time, the U.S., and I remember this very clearly because at the time I was working at CIA in the General Counsel's office, and I thought it was really interesting. I was teaching international law then. I was interested in the U.S.'s response to that. I was curious to see if any states actually took it at that time seriously. Now, not too surprisingly to me, the U.S., as well as allies, paid no attention to it. In fact, kind of thought it was a little ridiculous that the Russians thought that we would sit down and negotiate this treaty that would be prohibiting these cyber weapons, especially given the most recent history on the Chemical and Biological Weapons Convention, where we, maybe 10 years earlier had come to the final conclusion where we had enough evidence to know for certain that the Russians had been cheating on those conventions, right? The chemical and biological weapons. So it was for an area where to be able to verify compliance is, not completely impossible, but in 1998 was thought to be virtually impossible. There was no real effort to sit down and negotiate such a treaty. Interestingly enough, the Russians, since 1998, all the way up to today, are at least consistent in what they believe is necessary in this space to regulate state behavior. They're still calling for a new treaty for cyberspace. But since 1998, and it really started in 2004, the UN, the Secretary General said we need to start, paraphrasing, we need to start looking at the threats that are posed by the UN called international ICTs, international communications technology. ICTs, in a nutshell, kind of it's cyberspace, where U.S. Diplomats and people would refer to it as, the internet. And since 2004, they've had groups of experts, government representatives coming in, into these groups, typically 15 and then 25 members represented, always the permanent members of the Security Council, which is interesting because you have China and US and Russia, three very powerful cyber powers, always within these negotiations. And so over the years, you can see how these different states have come down on certain positions with respect to cyber threats, but also I would chart it as starting in 2010. Starting in 2010, there was a focus on international law and the applicability of international law to cyberspace. In 2013, it was the first time the group came up with a consensus report saying that the international law in general applies to cyberspace. I mean, it's funny because I was teaching that for a number of years beforehand. Once in a while, I had students saying, well, why do you assume that international law and the UN Charter even applies in this space? Because there is no specific treaty. And I had always taken as, well, it was kind of course, it's not that there'd be no law. That's how international law would develop. But in 2010, really in 2013, at least the UNGG members agreed, including the 5P, that international law applies. So it kind of resolved that question. In 2013 and 15, they continued to reaffirm that agreement. By 2017, things got more challenging because the US's position with our allies, or the like-minded they're called, wanted to get into more specific details, not just that international law applies, but talk specifically in the consensus reports about how international law applies and specifically what principles of international law, even outside of the UN Charter, might apply. Big areas of disagreement. 2017, they did not come up with a consensus report because they disagreed on three specific areas of international law's applicability for cyber. First was self-defense. Russians were very persistent. Starting, I would say, you started to see them, even when they were agreeing that the UN Charter applied, they were saying at the same time, oh, but self-defense. There is no such thing as the right of self-defense in cyberspace. My view was that's interesting because Article 51 of the UN Charter incorporates, the customary right of the inherent right of self-defense. But so by 2017, it became clear that not only the Russians, but the Chinese, by then also the Cubans that were now members of the group, they were going to insist that self-defense was not a right recognized in cyber, as well as the law of countermeasures and the international humanitarian law, which became a big deal. The laws of armed conflict would be very important, at least the US's position, as well as other countries, to have them applicable in cyber in the context of any kind of conflict that involves cyber operations. So fast forward, so 2017 was the last attempt at getting a report. They didn't get it. There's a new UNGGE now that's actually currently going on. They will hopefully come up with a consensus report. There's some, question as to whether they'll get agreement. But in the meantime, there's been another process, a parallel process that the Russians promoted and proposed at the UN General Assembly. It was accepted in a resolution. The US did not like it, did not support it, but it was accepted. And that was a new group that was created, established in end of 2018, was operational in 2019. And they just came out with their first final substantive report. And that group is called the Open-Ended Working Group, OEWG. That group, interestingly, is any member of the UN can be part of that group. So much more participation. The idea was some states like Russia, China, they alleged that the UNGGE process was too insulated with only 15 and then 25 members. That still kept quite a few states out of the loop and not part of the discussions. And so now it's open to all states that are interested. And so if you read what's interesting in their final report, unfortunately, with respect to the law, if you care to look at it to find any more progress on agreement on the applicability of international law within the open-ended working group, you're not going to find that. I think the report's on the UN website. I'd highly recommend if you're interested in it to look at it. I believe it was March that it was officially released, maybe March 12th. And what's interesting is, so the report the only thing the report does with respect to the law, the legal part, because it does do some really useful other kind of progressive ideas on confidence building measures and capacity building. But in terms of international law, which is kind of my focus, the only thing it says is that it goes back all the way to the exact language of the 2013 and 2015 UNGG reports. And what it says is international law is applicable, and in particular, the UN Charter. And that's it. Now, what is interesting is on the same website, the UN, you'll see in that report, it wasn't that long, but there's a compendium that was put together, and I was really glad. It's like the legislative history, if you will. First time ever, they put together, and this is 91 pages, and this is a compendium of state positions with respect to all the items in the open-ended working group final report. And not surprisingly, quite a few of the states objected to certain provisions that were in the so-called consensus report of the open-ended working group, right? It's supposed to be a consensus report, but as far as the law goes, it doesn't say much. It affirms the applicability of the law and the UN Charter it mentioned specifically. It doesn't mention any of the specific principles that got into the 2015 GGE report that people were excited about if you were an international lawyer, like the general principles related to the law of armed conflict, although it doesn't mention armed conflict or LOAC or Geneva or Hague Convention. At least the 2015, the negotiators slipped in the words humanity, necessity, proportionality. But that doesn't appear in the open-ended working group most recent final report. And in the compendium of state positions, there are a number of states, the US, the Australians, New Zealand, Japan, a number of states that call this out, that they say that they wished for more, that they wished that there were other principles in the GGE that had already been agreed to that were put in. But there were also other states that said, well, we think that that was going too far. And the last part of the open-ended working group, the very last paragraph has become kind of controversial, paragraph 80, because if you read it just quickly, it doesn't seem to say much. But when you read the compendium, what the states understand it to mean while they were negotiating this was there's a phrase in that short article that says there may be a need, or we should look at other instruments to be negotiated to deal with regulating state behavior in cyber. Now, that's kind of code word for what China and Russia have been arguing, Russia since 1998, that we need a new treaty. But states like Estonia, the US, and a number of other like-minded, even Japan, New Zealand, have said that we don't need a new treaty, but that we have the laws, both treaty law and customary law, that should be and can be applicable in this space. So unfortunately, although some have described this new open-ended working group report as I've seen words like a breakthrough, something that's like amazing. Unfortunately, I don't mean to be a downer or a pessimist, but as an international lawyer, if you're looking to what breakthrough on any kind of insight into how states are thinking the international law applies, you're not going to get it, unfortunately. So I guess the jury's still out as to whether the GGE is going to be able to make progress. And talking to friends that are from different countries, the cyber diplomats in that group that are working right now, I mean, they're still trying hard, but they're kind of got this uphill battle. And they also have to contend with the fact that they've got this parallel process that's also looking at the applicability of law in this space, and they're struggling with how to come up with something that's acceptable to all parties, at least the 25 states that are in the GGE right now.
Thank you for listening to this episode of Horns of a Dilemma, and please don't forget to visit our website at tnsr.org.